Hi, I'm Chris Wistrom with Disability Network Lakeshore, and this is DNL Live. And I wanted to talk to you tonight a little bit about advanced directives. And I have a PowerPoint that I'm going to share the screen with you. And here we go. So I learned about advanced directives when I was working as a long-term care ombudsman. And in the nursing homes, it was not unusual for people to think that they had the right to make choices for their loved ones when they really had no authorization to do that. So what is an advance directive? It's a written document that you use to give a competent individual the authority to make informed decisions for you should you become incompetent. And if you're over 18, you should consider executing an advance directive, because if you can't make decisions for yourself, then the law allows your family, your doctor, and your health facility, like your hospital or your nursing home, to have the ability to make those decisions for you. And so if you don't want that to happen, you need to consider making an advance directive. Now, you can do that through probate court by petitioning for a guardianship over the person. And a guardian is appointed by probate court by the judge, and the judge decides what powers to give that person. It can be a limited guardianship, or it can be pretty much anything that needs to be decided upon. But the person who you're making the decisions about is called the ward. As the guardian, you have control over where the ward lives. You can consent to medical treatment for them. You can receive money and property belonging to the ward. And then you can apply that money toward the ward's support and care. You can't take money from something that you've sold of the wards and use it for yourself. And that's called a fiduciary obligation. The guardian has a fiduciary obligation to act on the behalf of the ward in accordance to the ward's expressed wishes. Again, that is done through the probate court. Now, there's also the possibility of a conservatorship. Sometimes the guardian does not have the authority to make decisions over the financial property of the ward. And in that case, a conservatorship might be also appointed. And they manage the person's property and financial affairs. But another way of giving power to someone is through a power of attorney. And a power of attorney means that you give someone else the power to make decisions for you. And that can be executed at any time, and powers can be granted to anyone. It also can be durable. And we're going to talk more about durable powers of attorney shortly. But a durable power of attorney doesn't go into effect until you're declared incompetent by two doctors or a doctor and a psychologist. So you give someone that power, but only to use if you do become incompetent. Now, a durable power of attorney, that document by which you give another person power to handle those legal affairs, you sign it voluntarily, and you give that person the power of decision-making to act on your behalf. For instance, if you had children and you were going to go on vacation and your sister was going to take care of your kids, and you wanted to be sure that she could make decisions if one of them was injured, you could give her a power of attorney over the medical decisions on those kids that would become effective immediately. But a durable power of attorney becomes effective only in the event that you become incompetent. So powers of attorney, they can be used for making decisions over all of your property and financial affairs. It can also be over healthcare decisions, and that's called a durable power of attorney for healthcare. And that's the most common form. In order to execute a medical durable power of attorney, you have to be of sound mind. And the person that you give the power to is called your patient advocate. And again, the patient advocate has to follow your expressed wishes to the extent possible. For example, if you say you don't want to be resuscitated, then your patient advocate should try to follow those instructions. Your patient advocate has to agree to accept the responsibility for decision-making on your behalf, and they have to sign the document accepting that responsibility. And that includes the responsibility to take reasonable steps following your desires and instructions, whether you leave them written or whether you just said them. As long as you were competent when you expressed them, the patient advocate has to try to follow them. Now, you may also give them the ultimate power, the power to withhold or withdraw treatment that would allow you to die. But if you decide to do that, you have to express that directly in the forms and acknowledge that those decisions could or would allow your death. Now, you can appoint anyone that's 18 years or older as your patient advocate, but you want to choose someone that you can trust because they're going to have a say over what can happen to you, and that's pretty important. You also want someone who's mature enough to handle the responsibility and who's willing to serve. And it's a good idea to have a backup person listed on your forms too. How do you appoint someone? Well, you sign a document. It needs to be witnessed by 2 adults who are not family members, who are also not your doctor or the proposed patient advocate, and who aren't employees of health facilities or a program where you're a patient or a client. There is another type of advance directive called living will, but it is not recognized under Michigan law. It still might be worthwhile, as judges may assign some value to them as guidance as to the wishes of the person who executed the document. You can also do what's called a do not resuscitate order, which is a written document where you express your wish that if you have a health event where your breathing and heartbeat stop, you don't want anybody to resuscitate you. And without a DNR order, a do not resuscitate order, emergency personnel will do all they can to bring you back. And that includes pounding on your chest, shocking your heart. A lot of times they break ribs. It's pretty awful what they do. And there's only a 10% chance that you will recover to the same place that you were when that happened. So these are things that you need to be thinking about. So if you care about what might happen to you in the event you're deemed incompetent, you need to consider creating an advance directive. And the type you choose is entirely up to you, as long as you're competent. But consider carefully who would be best at handling those tough decisions and someone that you trust. So if you need more information or if you have questions or concerns, you can call Disability Network Lakeshore at 616-396-5326, or you can email chris@dnlakeshore.org. Thank you for listening tonight. I wish you luck, and I thank you for being with us. Good night.